Okay, I'll get started. Thanks for joining me today, everyone. So this is our contract training. The topic is inspection contingency, and we'll talk about the right to cure as well. I will try to stop from time to time and check the chat, or better yet, unmute if you want me to stop if you have a question, because it's kind of hard to see the chat when I'm sharing my screen. So again, if you have questions, just unmute and holler out. So I am in zip form. I'm in a residential offer to purchase. And we're going to be going through page 4, which is all of page 4 covers the inspection contingency. So at the top of page 4, there's a paragraph about what is the difference between inspections and testing. So that's just one thing to be cognizant of, is that the inspection contingency only covers inspections. A testing contingency, if your buyer wants to test for items, that is a whole separate contingency. So a test might be mold or testing water, testing the air samples, anything that they have to physically take a sample of and bring it to a lab to test. Asbestos is another example. That is defined as a test. So always good to have both an inspection and a testing contingency. So the testing contingency is found in Addendum A, specifically GMAR Addendum A. Remember, there's 2 different versions of Addendum A. We like the GMAR version of Addendum A. So again, at the first paragraph talks about what an inspection is versus a test. And then it also goes on to say on line 184 or 183, the seller agrees to allow buyers, inspectors, testers, appraisers reasonable access to the property upon advance notice, if necessary to satisfy the contingencies in this offer. Buyer or licensees or both may be present at all inspections and testing. So agents are not required to attend the inspection, nor are the buyers. However, it's our office, I guess I could say policy, or highly, highly recommend that you as the buyer's agent attend inspections. Granted, right now during this coronavirus period, we're not encouraging that because the less people in the house, the better. But during normal circumstances, it is highly recommended that agents attend home inspections. It's also a really, really great learning opportunity to learn about the mechanics of a home and how they work, and really kind of help you understand and how to interpret the home inspection report so you can help your buyer and the seller come to an agreement once the inspection is all complete. And then it goes on to say that except as otherwise provided, seller's authorization for inspections does not authorize buyer to conduct testing of the property. So again, testing is a separate contingency. Buyer can only test for items if they have that testing contingency. Lines 187 to 189, there's a note. Any contingency authorizing testing should specify the areas of the property to be tested, the purpose of the test, any limitations on buyer's testing, and any other material terms of the contingency. So just another note about the testing. Goes on to say, buyer agrees to promptly restore the property to its original condition after buyer's inspections and testing are completed unless otherwise agreed to with the seller. So when you're on a home inspection, you'll notice the inspector will try to move items if he or she needs to, if it doesn't create too much of an issue to move things back. But it's kind of more the responsibility of the inspector. And that the buyer agrees to promptly provide copies of all inspection and testing reports to the seller. So every agent does this a little bit differently. Some agents, as soon as they get that report from the home inspector, they forward it on to the listing agent right away. So the listing agent can start to review that report with their seller. Others might wait until they deliver an amendment or a notice over to the listing agent. I think every agent probably has their own reasons why they do it a certain way. But regardless, the keyword is prompt. So you can't wait too long to deliver that inspection report over to the listing agent. And then it states that the seller acknowledges that certain inspections or tests may detect environmental pollution, which may be required to be reported to the Wisconsin Department of Natural Resources. Never heard that issue come up, but. All right, so now on to the contingency itself. So to include inspection contingency, you're going to put an X in that box. And then it states this contingency only authorizes inspections. Again, not testing. This offer is contingent upon a Wisconsin registered or Wisconsin licensed home inspector performing a home inspection of the property. So you can't just have any random contractor come in and do a home inspection. They have to be a Wisconsin registered or Wisconsin licensed home inspector. And again, they're performing an inspection of the property. So property is defined. Let's see if I can quickly find that. Towards the end now, they moved all the definitions, which is nice. Let's see. Where is it? Property, line 453. Property means the real estate described at lines 4 through 8. I don't know why I thought there was a longer definition of that, but so essentially the entire property. So the land, the everything on that property. All right. This offer is further contingent upon a qualified independent inspector or independent qualified third party performing an inspection of blank. So here's where you can identify specific components that the buyer wishes to have inspected. So they give some examples: a swimming pool, the roof, foundation, chimney. So this would be if the buyer wants to have somebody else besides the home inspector come in and perform an inspection. But again, they have to be a qualified independent inspector or independent qualified third party. So licensed plumber, licensed roofer, licensed structural engineer, etc. It does go on to say that the buyer may have follow-up inspections recommended in a written report resulting from an authorized inspection. So including items here, if the buyer is saying up front, I don't really need to get the chimney inspected right away or the foundation inspected right away, but if the inspector deems it necessary, then I will want to. So you don't necessarily have to include anything on lines 198 to 199 because the third part of this is that follow-up inspections are included in this as long as the home inspector, the general home inspector, puts it in their report that they recommend a follow-up inspection. So obviously home inspectors are not experts in each particular area. So many times when they see an issue, they will reference in the report, okay, I'm noticing the foundation is maybe a ½ inch out of plumb. I recommend a foundation specialist or structural engineer come in to further evaluate. Same thing with chimney, same thing with the roof, HVAC. So they're only, test or inspecting a bit of it. And if they feel like further inspection is warranted, then they would recommend that. Lines 204 states that buyer shall order the inspection and be responsible for all costs of inspection. So really important to have that conversation with your buyer ahead of time, especially during the buyer consultation is a really good time to make them aware of what are some of the expenses that they will incur during the home buying process. Inspections typically run, it's been a while since I've ordered one, but $450 up to $650. 500 is probably average. So always good to make the buyer aware of those expenses up front. Okay, lines 205 to 206 is a caution. The buyer should provide sufficient time for the home inspection and or any specialized inspections, as well as any follow-up inspections. So after your buyer gets their accepted offer, one of the first things they should be doing is Well, one is delivering their earnest money, 'cause that's the first deadline. And two is scheduling that home inspection. So if you have, we'll go on to talk here about the deadline. Typically inspections are anywhere between 10 to 15 days. So if you call the inspector right away, they might not be able to come out, you know, until the following week, and maybe you're already day 6, 7 into your contingency period. That doesn't give the buyer, you know, the buyer only gives the buyer certain couple more days to one, do the inspection, and then do follow-up inspections and talk about what repairs the seller may or may not want to do. So really, really important to get that scheduled right away. So with that, like I said, the number of days is typically 10 to 15 days. So it states this contingency shall be deemed satisfied unless buyer within blank days. So it defaults to 15. I would say, again, 10 to 15 is typical. I see 14 a lot, 2 weeks for the inspection contingency. So within, let's say 14 days after acceptance, the buyer must satisfy this contingency. So there's a couple things that all must happen before this 14-day period is up. So one is that the buyer has to have the inspection and any follow-up inspections. They have to have the time to review that inspection report, discuss it with you as their agent. Then they have to bring to the seller, here's what I want you to repair or take care of. The seller either has to agree to those items to be repaired, and this would happen on an amendment. And if the seller doesn't agree, then the buyer would need to deliver a notice of defects. So all of that needs to happen before this deadline. If this deadline passes and an amendment is not executed, or a notice is not delivered stating that there is defects, then the buyer is risking purchasing the property as is. The seller is no longer obligated to say, yes, I'll repair these things so that we can continue moving forward. The buyer's essentially, once this deadline passes, the buyer has waived their inspection contingency automatically, and they can't walk away from the property based on the inspection. In the event you and your buyer find yourself kind of really close to that 14-day deadline and you haven't reached an agreement with the seller, it is possible to extend the inspection contingency deadline. That would happen through an amendment, and it has to be signed by both buyer and seller before that binding acceptance deadline. But it is possible to extend the contingency. So it's a simple statement of inspection contingency is hereby extended through April 14th. Okay, so line 210 is another caution, and this goes back to what I was just saying, that a proposed amendment is not a notice of defects and will not satisfy this notice requirement. So remember I said the buyer has two options when after they do their inspection and follow-up inspections. Now they have kind of a list of things that they would like the seller to take care of. So the first step would be to deliver an amendment to the seller, saying, seller, I want you to take care of these items before closing. The seller, what am I trying to say here? So if the seller does not accept that amendment, and let's say you're on day 14 of your inspection contingency, if seller does not accept that amendment, that proposed amendment does not satisfy the notice of defects. Those are two completely, a proposed amendment and a notice of defects are two completely different things. And I'm going to talk more about that in a minute. And I think we'll come back to this line because a few agents have kind of gotten themselves caught in tough situations because they thought, okay, well, I delivered an amendment, the seller didn't sign it, so it's not my fault. Well, no, you have to deliver a notice in order to satisfy the notice requirement. And the notice then triggers the right to cure. So just to kind of break it down a little more simply, when the buyer does their inspection and they're negotiating repairs for the seller to make, the best case scenario is that the buyer and seller are able to agree upon an amendment, or I should say best case scenarios, there are no defects and the buyer's like, we're good to move forward as is, we can just waive the contingency. Or next best scenario is that there's just a few items that the seller is willing to fix. So here's the list of them in this amendment. This is how they're gonna fix them. They're gonna fix them by this time period. Buyer and seller both sign it. The inspection contingency is waived, we move on. So in the event buyer and seller cannot agree on what that amendment states and what repairs the seller is completing, then the buyer has to determine, okay, do I need to deliver a notice of defects? So let's just talk about right to cure and what the two differences are between giving the seller the right to cure and not giving the seller the right to cure. So with the right to cure, essentially, regardless of the defects, the seller will have the right to fix and then fully expect the buyer to purchase the property. So giving the seller the right to cure, ultimately, the decision falls in the seller's lap as to whether this deal continues to move forward or not. The seller is going to say, yep, I'm going to cure the defects, or no, I'm not, and then the deal is null and void. If buyer does not give seller the right to cure, then the decision ultimately falls in the buyer's lap of, is this transaction going to move forward or not? If the seller does not have the right to cure and buyer delivers notice of defects, the deal is automatically null and void. So if you're working with a buyer, it's really in your buyer's best interest not to give the seller the right to cure, in my opinion, because again, it gives the buyer the ultimate say, the unilateral say as to whether this deal is going to progress or not. Now, if you're competing against other buyers, you might want to consider giving the seller the right to cure, because obviously that's more appealing to the seller. Because again, the seller has the unilateral say as to whether this deal is going to stay together or not. So I will say buyer's remorse is a real thing. Buyers many times after they go through the inspection, they may say, oh my gosh, we're just not in love with this house anymore. We don't love it as much as we thought we did. How do we get out of this? If they did not give the seller the right to cure, and again, if there are defects as well, it's a really quick, easy, clean way for the buyers to say, you know what, here's our notice of defects, we're walking. Again, there has to be defects, but that makes things a lot smoother. Whereas if they had given the seller the right to cure, and all of a sudden now they're like, you know what, there's defects, they are significant. We understand that the seller has the right to cure, but I'm not comfortable moving forward with this transaction, even if the seller fixes these items. I don't want to move forward. Well, buyer's hands are kind of tied because they've given seller the right to cure, and it's up to the seller to determine if the buyers are going to be able to walk or not. Any questions on that kind of overview of right to cure? Okay, so again, just making sure I covered everything here. So again, if the seller does not have the right to cure, the buyer still has the option. So that's one thing I forgot to mention. The buyer still, if the buyer does not give seller right to cure, the buyer still has the option. They can still ask the seller to fix things. And again, that would happen through an amendment. But then the other piece to that is if the seller is refusing to make those repairs that the buyer wants, or if the buyer just doesn't want them to make the repairs, they can unilaterally walk away. Okay. So let's talk a little bit about defect. So the definition of defect is right here in the inspection contingency section. It is a condition that would have a significant adverse effect on the value of the property, that would significantly impair the health or safety of future occupants of the property, or that if not repaired, removed, or replaced would significantly shorten or adversely affect the expected normal life of the premises. So it's a pretty clear definition, but I will say everybody interprets this a little bit different, especially with the word significant. What might be significant to a buyer might not be significant to the seller. And I see these arguments all the time. Or what's significant for a $200,000 property might not be significant for a $1 million property. So you kind of have to, it's not totally black and white. So there's always disagreement over, well, what is or is not a defect. We can't give legal advice. We're not attorneys, so we can't really say, yes, this is a defect, or no, this is not a defect. What we can do is rely on the inspection report, obviously also rely on this definition, and help our buyers understand what is significant effect on the value of the property, or impacts the health or safety. So most inspectors, they'll have a summary page and they'll list items under major concerns or safety concerns. So you can kind of use that as a guide of, okay, these probably could fall under the definition of defects since they're a major concern or a safety concern. What's coming soon, which will be great, is some law just passed with regards to home inspectors, and kind of educating them on this definition of a defect. And it will allow them to actually use that word defect in their reports as long as it matches this definition. So I think that will help clear up a lot of this gray area of, well, what is or isn't a defect? I think we'll still see a little bit of that, but I think it will help. So that'll be, I think, this summer at some point, that will fully go into effect. More on that to come. The other piece of defects is lines 211 to 212 states, for the purposes of this contingency, defects do not include structural, mechanical, or other conditions, the nature and extent of which a buyer had actual knowledge or written notice before signing this offer. So in the event the buyer has to deliver a notice of defects, they cannot claim defects that were disclosed on the real estate condition report, because they had previous knowledge of those. So if the seller disclosed in the real estate condition report that the roof is at the end of its life, it needs to be torn off and totally redone, then the buyer does their inspection, inspector finds nothing else wrong with the property except that the roof needs to be replaced. The buyer could not walk based on the roof defect. They had prior knowledge of the roof. So they could not claim that as a defect. Okay.
Hey, Kimmy, just to add to that, if you can hear me. Can you hear me?
I can hear you.
I would say a lot of times with working with buyers in this scenario, especially if there's something on that condition report that they still would like to have investigated further or have someone come out to the property, that might be a line that you would consider striking. I know that people have brought that up before, so I just wanted to add that note.
Thank you. Yeah, that's very true. A lot of agents do this. They will strike lines 211 to 212. And in addition to striking, any language in the offer, it's always best to also include it in the additional provisions that you actually write out. Lines 211 to 212 are hereby removed from the offer. But by removing these lines, that would eliminate the risk of a buyer. So again, the roof example, had they struck out 211 to 212, the buyer could still deem the roof as a defect. Mm-hmm. So a lot of agents use that strategy to protect the buyers. And so again, anytime you're making decisions on right to cure, or do I strike this or not, it's really kind of, I think, situational. and you have to see, okay, what kind of property is it? Who are we competing against other buyers? Because any kind of contingency or language you strike that works in the benefit of the buyer, that looks less appealing to the seller. So those are always things just to consider with each offer you write. Okay. So I'm going to back out here and I'm going to pull up an amendment. So let's say buyer has done their home inspection. They, the home inspector came back with a list of major concerns, some safety concerns. So the buyer's at a point now where they want to ask the seller to make some of the repairs. So you would do this by drafting an amendment to the offer to purchase, completing the information at the top, lines 1 to 3, and then jumping down to this other section. So in an amendment, the buyer can essentially ask for anything. It doesn't even necessarily need to be on the inspection report. Obviously, the seller is more likely to accept an amendment if it's reasonable and it pertains to items in the inspection report, but theoretically, a buyer can ask for anything in the amendment. You could address the closing date in this amendment. You could also, okay, I want the seller to repair these 5 items, but I also want a price reduction of $5,000 now that I'm aware of what's going on with the property. So with regards to asking for repairs though, there is a clause in the clause library that I'd recommend you use to protect your buyer and make sure buyer is getting the information in a timely manner. So if you click on the pencil icon, and again, I'm in zip form. If you work out of DocuSign a lot, DocuSign does not have the clause library, so zip form is recommended for that reason. So under the offer to purchase category, there is this inspection amendment. You can insert that. And this language states, the following shall be completed at the expense of the seller with all applicable lien waivers, invoices, and permits provided to the buyer no later than 10 days prior to closing. Upon acceptance by all parties, the inspection contingency as described in lines 410 to 423, and I'm realizing I probably need to change those line numbers since the offer was updated, of the offer to purchase is hereby waived. So then from here, you would go on and list what are the repairs that the buyer would like the seller to do. So maybe it's replace the roof, and again, you're going to be using that inspection report to determine what are the repairs that need to be made. So again, just making that list of items. With the amendment, again, the buyer can ask for anything. The buyer can specify who is doing the repairs. So you could say seller to hire A&D roofing company.
Yeah, this is obviously, sorry to interrupt, Kimmy. This is the most important part, to be really clear on what you're asking for. Who, what, when, where, how, and then what if, what would happen basically if the seller, would have someone else do it, for example. Like, this is the part to not be unclear about what you're asking for. So
yep, be as specific as you can.
Yeah, and the other thing that I was going to mention too is that if you're going through I'm Catherine, by the way, I'm the counterpart to Kimmy at the Lake Country office, for those of you who don't know me on this call. But I would say too that some buyers, when they're walking through the property, or based on the real estate condition report, the buyer can also ask the seller to take care of X, Y, and Z thing as part of your offer. So for example, when Kimmy was talking about a roof that needs to be replaced, let's say the seller is saying that in the real estate condition report, there's no need to wait until the inspection to be done if you wanted to ask for that up front, that they're, as part of your offer, they're agreeing to fixing items. I would just be sure to use the same language that Kimmy has here with addressing it in a way, that's going to be beneficial to the buyer. You're having a contractor do it, you're getting the receipts and lien waivers, et cetera. So
Yep.
another
I have a great example,
approach.
just being, as far as being specific. So I had a buyer, there was some trees that were dead in the backyard, and the way I had written the amendment, it wasn't entirely clear as to which specific trees, and B, like how much the tree was to be cut down. And so that created an issue when we did the walkthrough, when the buyer came through and they said, this isn't what I asked the seller to do. So yeah, when you're getting into the nitty gritty of writing this out, is just, again, being as specific as possible. The other really nice thing to do is, so when the buyer does their inspection, and then again, they have their follow-up inspections, if you can get kind of like a proposal from the roofing company, or maybe in hindsight, what I should have done is had a tree company come to the property, inspect the trees, and provide their report of, okay, here's what we would do. And then you can take those reports from actual experts who we should be relying on, because I'm not a roofer, I'm not a tree trimmer. And then you can attach those proposals here. And that will really ensure that the buyer or the repair is made absolutely correctly. I mean, hopefully, again, if you're using an amendment and you're able to say, okay, A&D Roofing Company is going to be doing the roof repair, the roof replacement, I know that they're really reputable and they're going to do a really good job. So I wouldn't have any concern with how it's done. So if you're using these professionals, then you can feel pretty confident that things are being done correctly without you having to get into too specifics. But yeah, all things to consider for sure.
And this is another opportunity too, to get quotes in advance. If you needed to, I've had agents like push back the inspection contingency for a particular item. So you can also extend it, you know, not leave it open to everything if you wanted to button up some of the other requests for repair.
Yep.
But for a roof, for example, that's a big ticket item. So if a seller doesn't really know what that's going to be and you're putting it in an amendment to ask, you know, upfront for that, you might consider allowing some time either to get that quote, have the buyer's roofing company come out and look at it, expect the seller will do the same and obtain a few quotes. But then allow the time, I think, with both parties. It's important, especially with that. Other things, you know, repairing a leaking sink, for example, in a kitchen, it's not going to be as big of a cost as a roof, a furnace, an air conditioning unit, a chimney, or foundation. All those big ticket items just allow for time.
Yeah, so true. The other thing that the buyer could ask for, and I know House to Home offers this, I believe, and I would imagine other inspectors do as well, but most inspectors will say, I'm willing to come back, you know, a few days before closing or once the seller has acknowledged that everything is done, I'm willing to come back and re-inspect those pieces to ensure that everything was done. But again, going back to what Catherine said, if you include that in the amendment, that seller to allow buyer's home inspector to come back and re-inspect, okay, what if if the inspector comes back to re-inspect and it wasn't done properly? You really need to have that contingency in place of, okay, in the event inspector, I don't know the wording off the top of my head, but in the event the inspector says, okay, this wasn't done right, then the seller agrees to repair again per the inspector's recommendation, something like that. So again, what's really great about the amendment is the buyer has the control to really be specific on how things are done, who's doing it, by when. So again, this is 10 days prior to closing, which is really good to give everybody kind of that big window of time, so you're not scrambling to get all this done like the day before closing, and then what if it's not all done? So giving a nice grace period in between that time frame and closing. Yeah, so again, with an amendment, like with any contract, there's always a binding acceptance deadline. So let's say my home inspection contingency deadline is Monday, the 6th. I probably don't want to make this deadline the 6th because maybe the seller doesn't agree or doesn't accept it, doesn't agree. I don't want to be scrambling on the last day of my deadline to come to a new amendment, to draft a new amendment. So 24 hours is pretty typical. But again, this needs to be executed prior to the deadline. That is what is key. So if you're running up against a tight time frame, I would first try to extend the inspection contingency deadline so you're not scrambling to get this all done on the deadline. And then you as the buyer's agent draft or put in your information here, buyer sign, and then you deliver it over to the listing agent. Any questions on an amendment? Okay. So let's talk about a notice of defect. So in the event either seller does not agree to the amendment, so maybe they received that amendment, they don't agree to the terms, they're not willing to do anything, or if the buyer is just like, you know what, I didn't give the seller the right to cure, I'm done, I want to walk away, we have to deliver a notice of defect, again, before the deadline. So the notice of defect would state, this is a notice by buyer, so you would strike seller, relates to the offer to purchase, dated blank, accepted blank, and then include the property address. So it says notice is given that, and then you would state this is a notice of defects. Buyers object to the following. And then you are literally making a list of those defects. So roof is leaking, and maybe even be more specific about where the roof is leaking. Foundation is 3/4 inch out of plumb. You know, whatever those defects are, you would make a list. So in the event seller does not have the right to cure, buyers deliver this over before the deadline, the offer is null and void. In the event seller has the right to cure and buyers deliver this notice before the deadline, this again then triggers the seller's right to cure. So the seller then has so many days, go back here to the offer to purchase. Actually, before I start talking about that, let me just talk a little bit more about the notice. So the difference between the notice and the amendment, you'll notice we cannot specify how work is done here, who is doing work, that they have to provide lien waivers and invoices. That's that part stated in the offer, but all you can do on a notice of defects is simply state the defects, just as facts. So I've seen some notices written that kind of copy what's written in the inspection report, which is just kind of like an evaluation of certain items, and it doesn't even really clearly state, well, what is the defect that they're pointing out? Be very factual and to the point. What is the defect that the buyer is objecting to? So going back to this offer to purchase, so down here, right to cure. So if the seller has the right to cure and the buyer delivers notice of defects, so on line 219, you as the buyer's agent have the option to specify a number of days that the seller has to decide whether they want to cure the defects or not. So it's default to 10. I would make it shorter if I were working in the best interest of your buyer. It just gives 10 days is a long period of time for the seller to kind of sit and stew on, well, do I want to cure the defects or not? So, I mean, I would say 5 days, 4 days, shouldn't take the seller too long. The only piece that, so what the seller would probably be doing during this time frame the buyer delivers a notice of defects. They're going to take this number of days to do their own follow-up inspections, potentially. Or I should say have experts come out and give the sellers an idea of how much is it going to cost for these sellers to make these repairs. So if the seller needs to have a roofing company come out and a plumber come out and a foundation specialist come out, they may need more than 5 days. But again, that's, if they accepted 5 days to begin with, then they have 5 days. They can't change it after the fact. But so they're going to take this time period to make a determination of, can I cure the defects or not? If they elect to cure the defects, then they would deliver a notice back to the buyer. Just writing it over here. So they would deliver a written notice to the buyer within 5 days after the buyer's delivery of the notice of defects, stating the seller's election to cure. So that notice that the seller delivers back is a very simple: seller elects to cure the defects. Once they deliver that within this time frame, then the transaction moves on. And kind of behind the scenes, the seller is working on curing the defects in a good and workmanlike manner, including obtaining applicable permits where required. So that's really their only requirement as far as how is the work done. They have to do it in a good and workmanlike manner. If it's something that requires permits, then you know that they're going to have to hire a licensed person to do the work. But for some things like some small electrical items, you know, they probably don't need to hire an electrician to do it if they can, if they don't need permits to fix some electrical items. So that's kind of the risk as well of not giving the seller the right to cure. If the buyer is in this position, then they don't really have, you know, the seller doesn't have like strict guidelines on how to repair the items. So once the seller then fixes everything in a good and workmanlike manner, then they just have to deliver back to the buyer a written report detailing what was done, documented compliance with permit requirements no later than 3 days prior to closing. So that is if the seller has the right to cure. Any questions on that? All right, I think I've covered just about everything I needed to cover. Anything anybody wants me to go back to?
I'm just curious with the COVID-19, are you finding that it's hard to meet the 15 days for the inspection?
I haven't heard any issues, but I will say during this time, with all the contingencies, make it a longer period of time. So maybe 20 days for inspection, just because there's a lot of still uncertainty as to what might happen in the next couple weeks. So giving a longer period of time is certainly recommended during this uncertain time.
Okay.
But I haven't heard anybody having issues with scheduling inspectors and getting follow-up inspections done. That's a good question. Any other questions? Otherwise, I'll just bring to your attention, the WRA website has a ton of great resources with regards to the inspection contingency and, well, really like anything to do with transaction issues. So if you go to WRA.org and go to legal and the hot tip library by topic, this is like my Bible. I use this a lot. So what the WRA does is, hopefully you guys all know that there is a legal hotline that you can contact. So again, down here, legal, if you go to the hotline, you can basically post a question to the legal hotline, and there are attorneys working there that will answer your questions. I reach out to them a lot. So then what they do is they compile all those questions and answers, and they put them into a library. So if you ever wanted to read up more about the inspection contingency, you can search under offer to purchase, And then inspection contingency. Because as we all know, every transaction, no transaction is like the other. There's always something quirky or different about each transaction. So this will go through just, again, some Q&As of what to do in certain situations. So recommend if you have time during this quarantining period, this is just a really good, nice thing to kind of educate yourself and kind of play through some different scenarios. So highly recommend that. Awesome. Any other questions?
I have a couple things quick, Kimmy, that I often get questions on for my agent. So I just wanted to bring those up, if that's okay.
Absolutely.
What if a buyer doesn't want an inspection? That's one thing that that comes up often with agents in our office. And we do have language in the clause library as well, that I recommend to agents doing either in your buyer agency or an amendment to the buyer agency, just simply stating that your agent has recommended an inspection to be done on the property, but that the buyer is opting not to. So just so you have that language, because as you know, that inspection, having that inspection done and the report on file is part of, and having your compliance information in. So that's one note. There are obviously buyers that will choose not to. So, and that's perfectly fine. It's just, we always recommend having one, and that language is in the library, correct?
It is. Yep. So I'll show you really quickly. So like Catherine said, if you have a buyer that does not want to do an inspection, really good to have in writing from them that they're essentially waiving that opportunity. The best way to do that is to draft an amendment to the buyer agency agreement, because it's not something that would be incorporated into the offer to purchase. So amendment to buyer agency, open that up. And then again, there's language in our clause library that you would insert in here. So just click on our text box, that pencil, the scroll, and then amendment to buyer agency. And this is the only clause, buyer's waiver of inspection. So you would just insert that. And like Catherine said, it simply states that contrary to our recommendation, I, as the buyer, am waiving my opportunity to have a home inspection. I will hold KW harmless from any liability, blah, blah, blah.
Yeah, there is information as well in the disclosure. However, it's just good to have in writing as part of your buyer agency, because sometimes you don't know until you get to the specific property if you're going to have one or not. So that's one thing that I wanted to bring up. The other is, I've had issues come up after an amendment has been drafted and parties agree to it. But because some agents have different levels of interpretation on things, you might be drafting something that is agreed upon, and so you're moving forward and everything's fine until you get your receipts, right? So I've had this come up just recently too, where, an agent asked for something specific on the buy side. The seller's agent, or the seller's agent, is kind of working through the repairs with the seller. A lot of times they're doing it, right? They're hiring the licensed contractor, they're hiring the electrician. And unless they really are given direction, there might be some, missed information, I guess.
Mm-hmm.
So I don't know, Kimmy, how you've approached this with agents, but what if, like, buyer and seller disagree on a repair that comes back after the fact, like it wasn't done to what the buyer was expecting, and perhaps it's going to cost even more to get it to a place that a buyer feels comfortable with? How have you dealt with that before?
Yeah, so there's actually like two pieces that kind of, or another part of this as well. So one, if what you just said, if the repair is done and buyer's like, was not done the way we agreed upon.
Mhm.
And then 2, what happens a lot is, again, going back to that definition of a defect, and if a buyer delivers a notice of defect and the seller's like, this isn't a defect,
Mhm.
more often than not, the only recourse, hopefully we can enter into a new amendment that would acknowledge what was done, what should be done correctly. And if buyer and seller ultimately can't agree, then they have to be referred to an attorney,
Mhm.
unfortunately. I always hate when transactions come to that, but if there's not that mutual meeting of the minds, then they have to speak with an attorney. So our role as the agent, and that's why it's important to have a good relationship with your co-broke, is to hopefully work together to try to figure out, okay, how are we now going to get this corrected? There's not really an easy answer to that, but
I know.
yeah.
I just want to bring it up because it doesn't mean that, all hope is lost.
Right.
Like you were
Right.
saying, you have that relationship with the co-broke and express, the situation. Hey, we're saying we asked for someone to come in, and let's say there's language that I've used many times before, repair or replace as recommended by X, Y, and Z contractor. Well, that could very well be that someone goes in there and says it's fine. And the buyer might not feel like, well, is it really fine? Because my inspector flagged it and brought it up, so it really should be repaired or replaced as they recommend.
Yeah.
So it's just something to be aware of, I guess, when you're drafting a contract. Again, going through line by line, making sure the buyer really is clear on, what their priorities are in this contract, because ultimately they have to be comfortable with moving forward with what happens.
Yep.
And then if something, if a HVAC guy goes in, or if a chimney, inspector goes in and says, no, I can't do what's written here because that's not recommended. That's not the recommended repair, and I'll write that up. Just make sure that parties are aware that it's kind of that you're giving the professional his ability to have the final say, basically, in what the situation is.
Yeah, great point. You said something earlier that made me think about something else as well. So you'll notice, what happened to you'll notice on the amendment that it states, upon acceptance by all parties, the inspection contingency is hereby waived.
Mm-hmm.
So this is, I would say, it's especially important to ensure is in there if you're the listing agent. So let's say we're on day 7 of 14 of the inspection contingency period. Buyer and seller have already agreed to this amendment, but they don't include this language. The buyer essentially could come back 3 days later and say, well, I actually also want this.
Mm-hmm.
So until that deadline passes or it's officially waived in writing, the buyer can come back at any time and ask for more items to be repaired, or they could even deliver a notice of defects at that point.
Yeah.
So really, like I said, more important for the listing agent to protect your seller, that you acknowledge that the inspection contingency is waived once the parties have come to an agreement.
Mm-hmm.
Any other questions? Wonderful. Well, thank you all for joining me today. Next week's topic, I think next week I am doing it's compliance and command training. So 1 o'clock next week, we're going to be going through again zip form, how to sync it to command or DocuSign rooms and command. Yeah. Thanks for joining me.
Thank you, ladies.